Hello friends. Today, I will explain about FIR, First Information Report. FIR means First Information Report. FIR is the first document prepared in criminal proceedings. FIR is a document that places on record the victim's side of the story. FIR acts as a tool on which police authorities base and start their investigations. Hence, it is pretty clear that an FIR plays a vital role in criminal proceedings. Now, as the importance of an FIR is established, one must understand the legal perspectives attached to it. Section 1541 of the Criminal Procedure Code, hereinafter referred to as CRPC, 1973, makes it clear that an FIR can be registered in cognizable offenses only. Cognizable crimes are those offenses in which a police officer can arrest an accused without a warrant. Due to the nature of gravity involved in the offenses, police authorities can arrest without a warrant under CRPC. The classification of cognizable and non-cognizable offenses is furnished under the first schedule of CRPC. For better understanding, Section 154 CRPC is extracted below. Information in cognizable cases. Every information relating to the commission of a cognizable offense, if given orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction, and be read over to the informant, and every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it, and the substance thereof shall be entered in a book to be kept by such officer in such form as the state government may prescribe in this behalf. A copy of the information as recorded under subsection 1 shall be given forthwith, free of cost, to the informant. Any person aggrieved by a refusal on the part of an officer in charge of a police station to record the information referred to in subsection 1, may send the substance of such information, in writing and by post, to the superintendent of police concerned who, if satisfied that such information discloses the commission of a cognizable offense, shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to him, in the manner provided by this code. And such officer shall have all the powers of an officer in charge of the police station in relation to that offense. Who can lodge an FIR? Anyone who has information about the commission of a cognizable offense can lodge an FIR. It is not necessary that she should be the victim or eyewitness himself. A police officer can lodge an FIR on his own if he comes to know about the commission of a cognizable offense. In Hallu and Oz versus the State of MP, it was held that Section 154 does not require that the report must be given by a person who has personal knowledge of the incident reported. The section speaks of information relating to the commission of a cognizable offense given to an officer in charge of a police station. How to lodge an FIR? The process of filing an FIR is very simple. It is as simple as narrating a story to the police. The informant has to visit the police station, ideally near the crime scene, and furnish all the information she has pertaining to the commission of an offense. Section 154 of the CRPC gives a choice to the informant to furnish information orally or in writing. If the information is disclosed orally, then the report must be reduced to writing by the police officer himself or under his direction. The report must be read out to the informant. Every report, whether reduced to writing or submitted in written form, shall be signed by the informant. How to register non-cognizable offenses. In non-cognizable offenses, when an informant approaches the officer in charge, the officer enters such information in his book maintained as per the format prescribed by the state government. Secondly, a police officer can begin with the investigation for a non-cognizable offense only after receiving an order from the magistrate under Section 155(3) of the CRPC. The investigating powers of a police officer are the same in cognizable and non-cognizable offenses, except the power to arrest without a warrant. The Honorable Supreme Court in State of West Bengal in Oz vs. Swapan Kumar Guar in Oz 5 held that there is no such thing like unfettered discretion in the realm of powers defined by statutes, and indeed, unlimited discretion in that sphere can become a ruthless destroyer of personal freedom. The power to investigate into cognizable offenses must, therefore, be exercised strictly on the condition on which it is granted by the Code. Hence, it can be concluded that if a person wants to register a complaint regarding the commission of a non-cognizable offense, she has to first register a complaint with the magistrate having proper jurisdiction. There are no strict norms pertaining to the format of a complaint. A complaint can be in the form of an affidavit or petition as the case may be. After receiving the complaint, the magistrate will decide upon the issue of cognizance. If the magistrate is satisfied that a non-cognizable offense has been committed, he will order for further investigations. Remedies available if the police refuse to lodge FIR. Reason: it is not always illegal when the officer in charge refuses to lodge an FIR, as it all depends upon the reason because of which the police officer refuses to lodge an FIR. If the police officer refuses to lodge an FIR because the case does not fall within their jurisdiction, deals with an offense which is non-cognizable in nature, or it is outside their legal capacity to take cognizance of such an offense, in such circumstances the refusal to lodge an FIR is legitimate and justified. Although, if an FIR is refused on the ground of jurisdiction, it is mandatory for the police officer to record information about the commission of a cognizable offense and forward the same to the police station having proper jurisdiction. Otherwise, it would amount to dereliction of duty. 6. Statutory remedies. Under Section 154(3) CRPC, when an informant's right to register an FIR is refused, she can approach the Superintendent of Police and submit the substance of such information in writing by post. If the Superintendent of Police is satisfied that such information discloses the commission of a cognizable offense, then he might investigate the case himself or direct an investigation to be made by any police officer subordinate to him. Under Section investigation to be made by any police officer subordinate to him. Under Section 156(3), read with Section 190 CRPC, if an informant remains unsatisfied even after pursuing the remedy under Section 150, case himself or direct an investigation to be made by any police officer subordinate to him. Under Section 156(3), read with Section 190 CRPC, if an informant remains unsatisfied even after pursuing the remedy under Section 154(3), she can further pursue the remedy mentioned under Section 190 CRPC. This is a different channel to get the FIR registered. This remedy is similar to the process of registering a complaint for non-cognizable offenses. As through this channel, a magistrate first take cognizance of an offence under Section 190 and then order for consequential investigations under Section 156(3). Under Section 200 CRPC, a complaint can be submitted to the magistrate orally or in writing under Section 200 of the CRPC. After the submission of a complaint, the magistrate will conduct a hearing, deciding upon the complainant, and the witnesses thereof are examined on oath in front of the magistrate. Judicial remedy mandamus is one of the prerogative writs. Instrumentality or its functionaries, as the case may be, to compel them to perform their constitutional, statutory, public duty. Hence, a writ of mandamus can be filed under Article 226 or Article 32 of the Constitution of India, directing the police officials to perform their duty and register an FIR. Can I pursue the judicial remedy before the an FIR? Can I pursue the judicial remedy before the statutory remedy? It is a remedy is not an absolute bar while filing a writ petition. In other words, it is nowhere expressly mentioned that a writ petition cannot be filed if there exists an alternative remedy. Although, on perusal of the various High Courts and Supreme Court's decisions, it can be concluded that ordinarily, the courts prefer and advise to first exhaust the remedies available to an informant. Conclusion. It is very important for every individual to understand the basic concepts relating to an FIR. A complainant can understand his own case only after understanding these fundamental laws. Even a brief understanding of these concepts can be very helpful while deciding the proper course of action. Thanks for watching, and also please subscribe.